People or Jared Lepick versus Andrew Elliott.
Hello, Your Honor. I'm Jordan Lepick. I'm also on this case. Jared Lepick
Yes.
unfortunately was diagnosed with influenza A this morning, so he has his Zoom going and can mic in if need be, but he's got very little of a voice left at this point.
Okay. All right. And yes, I do see him signed in. All right. Andrew Elliott or Travicia, is it Burrell?
Traversa Borelli.
Okay, sorry.
That's
All
all
right.
right.
Okay, what are we doing on this case?
Last week, sir, you had asked that they be out of the house before the hearing today. And as of right now, they're still moving stuff out of the property. There are still people on property, including a couple of unauthorized additional roommates that weren't included in the lease. And we have yet to get in contact with Mr. Elliott. He is the named person on our lease. So we would just like to see what his status is. We haven't heard from him since the 7th. And the last thing we received from him in writing was an email admitting to the debt owed and the wrongdoing on his part, stating that he can provide the court of a copy with this email. In his own words, he states, "We will obviously not refute what you are owed. We have no intention to. We would honor the court decision of the debt, which would additionally include legal fees. Given our contract is under the laws of Michigan, there is very little that can be garnished as the bulk of my earnings are earned as independent contractor." In this email, he proposed a payment plan that we were uncomfortable with agreeing to because he's offered us specific payment arrangements over the last.
Can I stop you, please?
Absolutely.
All right. How much are you claiming is owed?
So as of right now, he owes $15,000 plus court costs of $234.43. If I may, could I give you like 90 seconds of backstory, sir?
Not really.
Okay.
Your Honor,
I
if
don't
may.
know that I'm necessarily going to need it.
Okay.
Ma'am, are you moving out?
Yes, we've returned the key. I have a couple of friends currently helping me move out the remaining things. I'm actually at the U-Haul Center right now, and they are getting the rest of the items out presently under the supervision of the land manager.
Okay. So, and ma'am, are you disputing the amount they're claiming is owed?
I am.
You are?
Yes, I am. We
Okay.
owe.
How much do you think you owe?
So we owe December and January. That's $10,000. We paid a $1,000 late fee in November and a $2,000 late fee in September and October. We believe that these should be subtracted from the total owed due to illegality of those fees. Also, we were subjected.
How much is monthly rent?
Your Honor, monthly
5,000.
rent is $5,000 a month. This is a 4,000 square foot house that we were under contract for them to purchase. And we have done a series of short-term leases as they were waiting on the sale.
Okay. So here's the thing. Is she right about?
Oh, so now the ghosting session in court, still moving out unauthorized roommates popping up like surprise DLCs and no sign of license the 7th. And then there's that email like, bro, if you're trying to dodge, maybe don't put a confession in writing $15K plus court costs. And now there's a request for 90 seconds of backstory. You know this ain't a TED Talk, the judge is already over it. Wrap it up, get the ruling, and let's move on before this turns into a full-blown Netflix docu-series.
Just listed off, I think, $4,000 of late fees that they paid.
No, sir, that is incorrect. Those were from the previous lease. See, at first we did a 60-day lease, and then we extended that once their house was not sold. So we have 2 prior leases to this short-term lease, and we only enforce late fees on one of the months under those leases. And I can submit documentation of all this, sir.
So can I.
All right.
I do have claims that ACHs were sent that were never received to my account, sir, as well as proof of funds that I received in December and no payment was made out of that. The last communication I had about a payment arrangement was on December 13th, and I was informed by Mr. Elliott that day that his wife had sent an ACH. However,
Okay,
I
look, folks. Oh, ma'am.
yes.
Here's what's going to happen. What date are you going to be out of the premises?
We're already out.
Your stuff
You're
is still
already out.
Right.
Your stuff-
And they have surrendered the keys?
Yes, and it's in the process of being removed as we speak. So we are out. It'll be another hour or two, I think, before it's all of our stuff is gone.
So then the only issue is what's owed.
Right. I also want to bring up, if I may, Your Honor, we were subjected to a wrongful lockout, so we are due 3 times damages of the $150 for a locksmith as outlined in Michigan's anti-lockout statute, totaling $450, which I also have evidence of.
Okay. All right,
Your
look,
Honor.
folks.
Your Honor, I'm
Yes.
going to my house because they failed to pay rent. I have 6 children. These people make $350,000 a year is what they claimed on the rental application. I'm going to lose health insurance tomorrow, and my house is going into a foreclosure period as of tomorrow is 90 days late. They have money. They had subletters or whoever living with them, and I don't know if they were running a homeless shelter, if they were pocketing the rent that their roommates paid. They've
No.
just been sitting in my house, sir.
This is incorrect.
Okay. All right. So here's the thing. Possession has been granted. There are 2 parts to the case. Possession's been granted or surrendered to the plaintiff. So possession is not.
Sorry.
Pardon?
There are still people at the house. One of them had a residence established there, apparently. They're still at the house. And unfortunately, our property manager expired at noon today, as it is the last day of the month. So any clean out of anything left behind, I'm going to have to go assess for any damages left on my own next week.
All right. Okay. So here's what I'm going to do. They've surrendered possession of the unit. Ma'am, to your knowledge, are there people in the premises?
Yes, there
Ms.
is.
Burrell, are there people still in the premises?
I don't know. I would have to text them. I don't know if they're on the premises presently, but we were told that we could get the remainder of the items out. So they would be doing that if they are not presently at the U-Haul Center where I am now. I'm just using my phone to do this.
Possession to the premises has been surrendered. Ma'am, as of given everything that I'm hearing, your management contract expires at midnight tonight? Is that the deal, or?
Yeah, yes. And we can't afford to pay a property manager anymore.
Hang on. I hear you. I'm just trying to, because you're in.
Oh, this just keeps getting Messier late fees from a past lease, a 60-day lease turned extended saga. Now it's a paperwork battle with both sides, ready to throw down with proof like it's a courtroom edition of Uno. And then there's a classic, I send the payment. But it never showed up move right, because money just magically disappears into the void at this point. Even the judge is probably thinking y'all better have receipts, or we're going to be here all day.
You're in North Carolina, right?
Yes, sir. But I will have to make a trip up to North Carolina to assess anything.
I know. I guess you're out of state. You've got a property manager here that won't be the property manager tomorrow.
Yes, sir.
So what? I should let you guys talk, and then I'll just go back and then come back out. Because either you're going to listen to me or not. Possession's been surrendered. I'm going to give the authority, I'm going to grant to the plaintiff the authority to prevent waste under 4.201I, that you may lock and secure the premises effective 3 o'clock today. The reason I'm doing that is so that you can get your property manager, go over there. You can order a locksmith. You can change the locks at 3 p.m. today. Whatever else needs to get out, if you don't get it out by that time, you said you surrendered, you're giving them the keys. They've given you grace to get some of the stuff out. If it's not out, not out.
That's
But the
perfectly fine, Your
premises
Honor.
will be locked.
Thank you.
Then the issue regarding the money is going to have to be done. Now, I might as well, because the parties don't seem to agree, set this matter for trial. You have to come up next week. Is that correct, ma'am?
Yes, sir.
Okay, so trying to time this, when, if you come up, how long are you going to be up here?
Very short amount of time, sir, as I have children in North Carolina in school. So a day.
Okay.
Enough.
So if I set, well, I was just going to set this for a trial. So I can set a trial date, but I'm going to need the parties in person because apparently there's going to be a lot of documentation. So I'm trying to set it. So here's what I'll do. Because we're really talking about the money, but we got to get the premises secured first. So we've dealt with that. What's my date? March the 4th? The 11th. All right. So what I'm going to do is I'm going to set a non-jury trial as to the money issues for March 11th, 2025 at 9 a.m. That's in person. So I've tried to set that, ma'am, I tried to set it out far enough so that you could make arrangements or do what needs to be done to come up. We'll hear it that day. So if it has to be a one-day trip, it's a one-day trip. But I've just tried to put it out to, well, I think you get what I'm saying. Okay?
Absolutely.
But I'm allowing you to secure the premises. You're going to come up here, check on it. That way you can assess what damages or other things there may be there. Bring ledgers, all other documentation you want the court to look at on March 11th, and then we'll hear your case. Okay?
Your Honor, might I ask one question?
Sure.
Rather than pushing it out, I can make arrangements. I will make it work. Like I said, we're actually going into a 90-day foreclosure period tomorrow. And so time is kind of of essence.
Got it. Then the best I could do is the 18th. What day? Yeah. But the best I could then do is February 18th. I could push it up to that day. Will that be better for you?
Yes, sir. Thank you so much.
So non-jury trial in this matter then will be set for February 18th, 2025, 9 a.m. Okay.
And one more question. Will Mr. Lepek have to appear as well, or will me be appearing sufficient just because he can't afford time off of work right now?
Well, he might want to have himself, if you're here, he may want to have himself. I will allow understanding childcare, work, those things. I would allow him to appear.
Clip 2. Ah, yes, the classic, are you going to listen to me? Or not moment, judge is done with the back and forth nonsense property. Manager gone tomorrow, possession surrendered. And now we're throwing legal codes around like it's some final boss move. Fort 2011 sounds fancy. Probably just judge speak. For wrap it up, I'm over it.
Zoom.
Thank you. And as far as
So
Mr.
that he's present, but you will have to be here in person.
Understood. And Mr. Elliott?
he needs to appear. If he doesn't appear, then I do what I got to do.
Okay, thank you, sir.
Your Honor,
Thank you.
may I ask a question?
Sure.
My partner might not be able to get off work either, but I can show up. Is that a problem?
I will give you the same. Okay. I will give you the same opportunity that I give the other side in fairness. So you may appear, but he would have to be available via Zoom.
Okay, thank you so much.
Thank you. Michael Scott Stone versus Kevin Smith.
Yes, Your Honor.
That's your names?
Michael
Kevin
Scott
J.
Stone.
Smith, sir.
Where are we on this one?
He has failed to pay me any rent or for the utilities since June of last year and refuses to pay. And I wish you to order a 10-day where he'll be removed by the sheriff within 10 days.
And did you send a copy of this information to him?
Yes, sir, I did. He received it yesterday at 2:33 p.m.
You have the documents?
Yes, text messages and yeah, it's nothing, Your Honor. He's just
So
trying
I'm going to have to
confuse
set
you.
this for trial. I do my trials in person. You're down in Florida. He's here. When I read through them, they're at least what potentially could be colorable defenses. I don't know until I hear the testimony.
Your Honor, I'm a working man. I make $24 an hour and I'm paying his rent and utilities. I'm living off credit cards.
Sir, you know, every time you come here, you try to tell me how this is going to be.
No.
You have property here in Michigan. You may be down in Florida. You may be a working man. I consider myself that too. This happens to be my job. Part of my job is setting a date for these trials to get them resolved. Now, if what you want to do week after week is sit here and try to lecture me on what Michigan law should do, then I'll just keep setting it every week. He'll come back. You'll just try to give me that lecture and we'll just move on. I'm trying to resolve the case. So I'm going to set a trial date.
So today's not the trial date?
No.
Okay.
I'm going to set a trial date. Maybe you didn't appreciate what I said. That trial date will be in person.
Well,
if you had listened to the case before, I realize there are people out of state. I will try to accommodate that the best I can. So I'm going to set a trial date in person. I can set it for February 18th or March 11th.
Your Honor,
your preference?
Can I have an attorney represent me there?
February 18th, sir. The reason being is because
I don't care.
Yes,
I
sir.
didn't ask that. Can you be here February 18th, sir, for a trial?
Can I hire an attorney to represent me there?
Pardon?
Can I have an attorney be there present for me?
Absolutely. You can have an attorney here.
Okay.
That might be wise, because then I don't get lectured.
Yes, Your Honor. So,
non-jury trial in this matter
Your Honor,
will be set February 18th,
yes, Your Honor.
2025, 9 a.m. in person. I will allow testimony over Zoom, but there needs to be a party here. Yes, sir.
Is on what basis is any of this evidence going to allow him to continue to stay there free? I don't understand.
Pardon?
There's nothing in any of this that it gives him the right to continue to stay there for free. I don't understand.
Then get an attorney, and then maybe then you'll have some clarification if you listen to him.
Okay. I don't understand his claim of how he can continue to stay there for free. There's nothing in those paperwork.
Okay, just because you rephrase the question doesn't change my answer.
Okay. All right. So I will have an
Sir,
attorney.
you had a question?
Not a question, Your Honor, a statement that I would like to make, please.
Oh. About what?
Mr. Stone and the status of the condominium, sir.
And the status of the condominium?
Yes, sir.
In terms of, go ahead. It's got to be brief, and I may cut you off.
Yes, sir. Very brief, very short. Mr. Stone has known since I'm sorry, Your Honor. Mr. Stone has known since 2022 that he should have the place registered as a rental property. Mr. Stone received.
That is a defense, and that you will raise at a trial.
Yes, sir.
I set a trial date, and God help me, I'll be here to hear all of it.
Yes, sir.
18th,
9 a.m.
9 a.m. in person. Thank you.
Yes, sir.
And just like that, we're yanked from one legal battlefield to another with zero hesitation one moment. It's a polite exchange of thank you so much, and the next is a full-speed pivot to Michael Scott Stone versus Kevin Smith. No room for second thoughts, no time to breathe, just an assembly line of verdicts and rulings. If you're not ready, too bad. The courtroom doesn't wait. It's almost like a legal drive-through where cases get processed at breakneck speed. Blink, and your case is old news 1 second. You're the main character, and the next you're just a footnote in a never-ending docket of next.